Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to head back down to California. We're going to do a follow-up to this video right here because last week, everyone in California woke up to find out that, oh my gosh, if I buy a firearm accessories, or ammunition, I'm now subject to a whole new 11% sales tax. And you know, it was the Supreme Court that actually, in a case many, many years ago, said the right to tax without limit or control is essentially the power to destroy. Well, that is exactly what the state of California is trying to do to all gun owners as well as the FFL industry. Now, they claim that all of this money is going to go to help gun violence prevention, but then again, they've also been claiming that all these laws they've been shoving down your throat for years was also going to help with gun violence prevention. Where has it gotten you so far? We all know better. We know where this money's going to go. You're basically going to be funding your own civilian disarmament legislation. It appears that there's not one, not two, but a whole bunch of cavalries, however, California coming to the rescue. We have a lawsuit. We want to talk to you about it. So today, let's spend a few minutes, let's geek out on the pleadings, and let's talk about the lawsuit to stop the modern day poll tax. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear. That's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, America, this is what we're talking about. We're talking about the case of James versus Maduros. It is actually filed in the Superior Court of San Diego County. It is a challenge to California's new 11% sales tax on a constitutional right unique to the state of California. Now, I said that there was several cavalries that were going to ride to the rescue here and try to save the inalienable rights of Californians everywhere. And those groups include the Second Amendment Foundation, the Firearms Policy Coalition, the NRA, and the California Rifle and Pistol Association. We're going to put links for all four of those worthwhile organizations down below so that you can show them some love. Of course, we're talking about California, which means we're going to do a quick shout out to our first ever California subscriber. Of course, that's Philip P. Philip P. has been spreading the gospel of Washington gun law ever since we started doing this, which, by the way, actually was 3 years ago officially today, the date that I am actually recording this, which is July 7th. Now, for those of you who geek out on the channel regularly, you know that I live by the adage that you never get a second chance to make a first impression. So how here do the plaintiffs set up their lawsuit? Plaintiffs sued to challenge the constitutionality of Assembly Bill 28, which imposes an 11% excise tax on gross receipts from the retail sale of firearms, firearm precursor parts, and ammunition. While this excise tax is technically levied on the sellers of these goods, in practice, it is passed through to individuals purchasing firearms, firearm precursor parts, and ammunition in California. Oh, you mean it's like when we're going to raise corporate taxes, that shockingly turns into just additional taxes on the consumer? Yeah, because any company that knows how to run itself will always pass those costs along to the consumer. And trust me, the California state legislature, as stupid as they are, they at least understood that. The plaintiffs also point out California's 11% excise tax is unconstitutional under the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruin because it implicates conduct protected by the Second Amendment's plain text and is not part of this nation's history of gun regulation. Defendant will be unable to present widespread, relevantly similar analogs from the founding era to support the tax. And that is completely true because this is something that has just been cooked up out of thin air in recent years, and where, of course, in the state of California. And so I know a lot of you sit there and when I do a video about California, you're like, why are we doing videos on California? Because you have to understand where the genesis of all craziness starts. It starts in California. And if you don't pay attention a couple years down the road, yeah, it's sitting right there on your front porch. But of course, the real issue is could we actually place a tax on the exercise of a constitutional right? Can you imagine every time you wanted to go to church, you actually had to pay the government a tax in order to go to church? Or maybe anytime you wanted to buy a Bible, there was an additional 11% sales tax on top of that? Or anytime you wanted to speak freely, or anytime you wanted to have right to counsel, you had to pay the government an additional fee in addition to what you're paying the attorney already. And so as the plaintiffs point out here, this is pretty well settled case law. Additionally, the United States Supreme Court has repeatedly held that constitutional rights cannot be singled out for special taxation. The excise tax plainly singles out Second Amendment rights for disfavored treatment. Because the Second Amendment is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees, these precedents apply with equal force to California's excise tax. And of course, the thing we have to remember, and this actually goes all the way back to the formation of our country, is that unbridled power to tax the citizenry is in fact the power to obliterate the citizenry. And so as the plaintiffs point out here, as the Supreme Court famously cautioned, a right to tax without limit or control is essentially a power to destroy, citing to McCulloch v. Maryland from 1819. Here, California effectively seeks the power to destroy the exercise of a constitutional right by signaling it out for special taxation. If this tax is permitted, there is nothing stopping California from imposing a 50 or even 100% tax on a constitutional right it disfavors, whether it be the right to keep and bear arms, the right to free exercise of religion, or any other right. Moreover, calling upon the courts to decide how much tax is too much would be a completely arbitrary exercise. The only rule that accords with precedent and common sense is that the constitutional rights cannot be singled out for special taxation. And so the plaintiffs here are correct in saying, listen, this is a dangerously slippery slope. If you say an 11% tax is okay, then 2 years from now it's a 50%, 4 years from now it's a 100%, and so on and so on. And so the only safe rule of law is actually to stick to Supreme Court precedent and say, no, this tax is unconstitutional. Now, we know where the state of California is going to come here. The state of California is going to come at this thing and say, hey, listen, the right to keep and bear arms, the Second Amendment, is not been implicated by this statute. This statute does not at all infringe on a person's ability to keep or bear an arm. The contrary argument is going to be like, no, it actually infringes upon the right to accumulate an arm, which the state of California will argue is not encompassed by the Second Amendment. We all know that to be complete and total BS, as does the plaintiffs, as they point out. To secure the core right to possess a firearm for self-defense, the Second Amendment's protections extend to necessary ancillary rights, including the right to acquire and sell firearms and ammunition for lawful purposes. After all, the core Second Amendment right to keep and bear arms for self-defense wouldn't mean much without the ability to acquire arms. And so in concluding their arguments, wrapping it up, putting a nice little bow on top, all of the plaintiffs here explain as follows. California's 11% excise tax on firearms and ammunition infringes plaintiffs' rights under the Second Amendment because it implicates conduct protected by the Second Amendment's plain text, acquiring firearms and ammunition, and is not part of the nation's history of gun regulation. Defendant will be unable to present widespread, relevantly similar analogs from the founding era to support the tax. Additionally, the excise tax impermissibly singles out constitutional rights for special taxation. The United States Supreme Court has repeatedly held the exercise of constitutional rights cannot be targeted through taxation. The excise tax, imposed on top of California's 7.25 generally applicable sales tax, plainly singles out Second Amendment rights for disfavored treatment. Because the Second Amendment is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantee, these precedents apply with equal force to California's excise tax. And then, of course, we need remedies, right? And the remedy is declaratory judgment after injunctive relief and then summary judgment finding the law to be unconstitutional. Once again, the plaintiffs, and there's a lot of big name plaintiffs on this thing: Second Amendment Foundation, Firearms Policy Coalition, National Rifle Association, California Rifle and Pistol Association. Links for them all down below. The case, once again, is James versus Maduros. We're going to go ahead and put the complaint down there so that you can geek out on it for yourself. We're going to certainly keep our eyes on this. This is going to be a very, very important piece of litigation. Otherwise, you're going to start seeing this craziness start spreading to a lot of other states. Listen, you may have more questions about this or anything else related to what's left of our Second Amendment rights. If you guys do, and you want to get a hold of Washington Gun Law, all of our contact information is down there in the description box. Maybe you got an idea for a video. If you do, go ahead and click on that link right there, because candidly, some of the best ideas we ever had weren't really our ideas to begin with. And then finally, and most importantly, let's everyone remember, the part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.